Hey folks, Elder Law Care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, got a great question today from one of our YouTube subscribers. Hey Patrick, what is the role of a healthcare proxy in medical emergencies? That's a very valid question that folks need to get their head around. What is a healthcare proxy? Folks, healthcare proxy is one of the big six disability planning. That is a legal instrument that will allow your healthcare agent, who is your fiduciary, legal authority to step into your shoes and make your medical decisions for you when you're completely incapacitated and unable to do so. Folks, extremely important that you have a healthcare proxy when you're alive and well. So when you become alive and not so well, you are covered. You are avoiding the arduous, expensive process of petitioning the probate court for guardianship. How to avoid that, folks, is making sure you have your healthcare proxy robust in nature with enhanced elder law powers, right, to avoid guardianship. And then the cousin to the healthcare proxy is the advanced medical directives, where you specifically spell out all your medical decisions to make it easy on your loved one, to give them confidence to make difficult decisions in a very difficult time. Also, it's designed to avoid conflict with medical professionals and family when emotions are running high. And from my experience, when you have it all reduced and memorialized to a writing, it's going to give your family some degree of comfort in a very sad time, because they're going to know they honored and respected your decisions and your wishes. That's going to make them feel some degree of comfort when they're mourning and grieving your loss. That's the importance of a healthcare proxy. And then the cousin to the healthcare proxy, the advanced medical directive, because the U.S. Supreme Court case on this matter says the court does not want to get involved in family conflict. So it's your job to leave clear and convincing evidence of your end-of-life wishes. And folks, what is a good example of clear and convincing evidence? Reduce it to a writing with your elder law attorney that will help you memorialize your end-of-life wishes. Healthcare proxy number one, cousin to the healthcare proxy, advanced medical directives, where your loved one can step into your shoes as your medical surrogate, exercising substituted judgment, avoid conflict with medical and family, give them confidence to make difficult decisions, and give the family some degree of comfort. And folks, another one I'm going to mention, if you are in the late fourth quarter of life, in addition to the healthcare proxy, in addition to the advanced medical directive, you ought to have a MOLTS. A MOLTS is an acronym, medical order regarding life-sustaining treatment, really memorializing your end-of-life wishes. It is a statute, Mass General Law, medical order regarding life-sustaining treatment. It carries a lot of weight and authority because it's subscribed under the laws by the legislature, and also it's signed off by a medical doctor or a licensed medical professional. The national form, I believe they call it a PULSE, physician's order regarding life-sustaining treatment. And lastly, folks, make sure you monitor that MOLTS or PULSE, because from my experience, things will change for families. I had a case a number of years ago where the family was optimistic and hopeful for their loved one. They filled out the MOLTS and they were hopeful, and they said full CPR, full code, transport to the hospital, hospitalize, give CPR, the whole medical procedures available. And then about 6 months later, their loved one's medical situation went from bad to worse. But since the medical facility had that MOLTS, the nursing home management had to comply with it. And every time their loved one crashed medically, they were forced to call 911 with the paramedics, resuscitating the person, rushing them off to the emergency room, to the intensive care unit, stabilize the person on machines. And about a week later, they would crash again. It was not only medically futile for that individual, that person who was completely incapacitated, but it was extremely heart-wrenching for the entire family to watch their loved one go through that ordeal. We had to go back into probate court and petition the good judge and ask them to give the husband legal authority as the guardian to change that MOLTS, because you cannot do it just by picking up a pen. You need legal authority, and oftentimes that legal authority has to be the healthcare agent and or a legal guardian with enhanced powers, because a regular guardianship typically won't even give those powers. So folks, stay ahead of the game, monitor the healthcare proxy, monitor the MOLTS or the PULSE, because things will change for your loved one. So don't just set it and forget it, monitor it and update it as needed, so that your loved one's end-of-life wishes are met while minimizing the drama and the trauma for the family. Hopefully you found this information helpful, folks. If you want to learn more, check out our other videos. Pick up a copy of my new book on Amazon, How to Slay the Metaphorical Four-Headed Beast, the top 20 strategies that will win the battle in elder law. Folks, thanks for being here today at elderlawcare.com.